Hello, everyone, and welcome to today's National NAGPRA Program webinar. My name is Melanie O'Brien, and I'm the manager of the National NAGPRA Program. Today's webinar will discuss notices that are required under NAGPRA. Before we get started, I'd just like to remind everyone that this meeting is being recorded. A recording of this webinar will be made available on our website after the meeting, along with copies of the PowerPoint presentation that I'm providing today. Your name and attendance at this webinar will also be recorded. If you wish to not have your name or attendance recorded, you may disconnect at this time. After the presentation, we will turn on the question and answer option for the webinar, and you may pose questions for live responses. Given the size of these webinars, we ask that you not raise your hand or ask questions through audio. We prefer all questions come through the Q&A in written form. If you have an issue during the presentation, you can use the webinar chat to reach me as the host, but otherwise the chat is disabled. So again, please refrain from raising your hand, but if you need assistance, you can use the chat to reach me directly. And when it's time for questions and answers, we'll turn on the Q&A feature to allow questions that way. So I have prepared a presentation for today's webinar. I will note that while I'm going to share this information in a PowerPoint presentation, all of this information is available on the National NAGPRA Program website. I have just extracted some of the details from our page on notices in particular and put it into this presentation format as a means of guiding my presentation today. But the information itself you can find on the National NAGPRA Program website under Compliance on the page called Notices and Statements. So I wanted to start off today by talking about notices in general. As you may be aware, museums and federal agencies are required by the regulations and the Act itself to give public notice prior to disposition or repatriation of human remains or cultural items. The reasons for this public notice requirement are generally one, to ensure that there is due process as well as transparency in the disposition or repatriation process. Now, if like me, you chose not to attend law school, you may be wondering what due process is. Generally, due process is a legal term that refers to rules and principles that have been established for enforcement or protection of rights and safeguarding the protection of individual rights. That's what due process means generally. In the specific terms here under NAGPRA, this notice process ensures protection of rights as well as transparency. And it does that by the second item here, which is the notice allows time for lineal descendants, Indian tribes, and Native Hawaiian organizations to make claims or make requests before any rights are irrevocably waived. The irrevocably waived language is found in the regulations in 43 CFR 10.1G, and is again the general principle that any lineal descendant, Indian tribe, or NHO that fails to make a claim or a request is waiving their right to do so. And so the notice provides that window of opportunity, for any of those parties to make that claim or request before that right is revoked. Finally, the other reason for the public notice process is that it protects not only the rights of lineal descendants, Indian tribes, and NHOs, but it also provides protections for museums and federal agencies by disclosing this process, making it again transparent and allowing those rights to be exercised. Okay. So those are the sort of general reasons why a public notice is required under NAGPRA. So what are the notices that are required? I wanted to try to provide this information in a very clear table format. Again, this same information is available on our website under the Compliance tab on a page called Notices and Statements. It's in a text format instead of a table format. But hopefully the information here is easy to understand because we often find that this is a point of a lot of confusion. Which notice goes with which process? So in the first column, you'll see I've laid out the 3 different processes under NAGPRA: the protection of human remains or cultural items on federal or tribal lands, and then repatriation of human remains or associated funerary objects, and repatriation of unassociated funerary objects, sacred objects, and objects of cultural patrimony. So again, the 3 different processes under NAGPRA are in the first column. In the middle is the corresponding notice that goes with each process. So for protection on federal land, the notice is a notice of intended disposition. For repatriation of human remains or associated funerary objects, the notice is a notice of inventory completion. And for repatriation of other cultural items, the notice is a notice of intended repatriation. And the last column explains why the notice is published or what the notice content identifies. And so again, for protection on federal land, the purpose of a notice of intended disposition is to identify the lineal descendant Indian tribe or NHO with priority for disposition. For repatriation of human remains or associated funerary objects, the notice of inventory completion identifies cultural affiliation of the human remains or associated funerary objects. And lastly, for repatriation of unassociated funerary objects, sacred objects, or objects of cultural patrimony, a notice of intended repatriation allows identification of a request for repatriation, that a request for repatriation has been received and accepted, and identifies the parties making the request. So again, there are 3 different processes under NAGPRA, depending on what type of human remains or cultural items are involved. And as a result, there are 3 different notice types that align with each of those processes, and each have a slightly different reason for those notices. What must be done to publish a notice? Again, this information and these questions actually come directly from our website. I've just reformatted them here in a presentation for you. The notices must be submitted to the National NAGPRA program, which is my office, at the email address nagpra_info@nps.gov. That's our general mailbox, but it is actually the authoritative mailbox for submitting any documents that are required under NAGPRA, but certainly under certainly for the notice requirements. We made the change in these regulations to require electronic submission to that specific email address. Now, in cases where electronic submission is not possible, we have alternatives, but the requirement is to make a submission by email to our general inbox. I'm stressing this point because recently we have received several items by mail, and those items by mail not only take a long time to come to the Department of the Interior and to the National Park Service, but then takes additional time to find its way to our office. And so I want to encourage you certainly and remind you that the requirement is electronic submission of any kind of document to the National NAGPRA program through our general inbox. Notices must conform to the mandatory format of the Federal Register and include all of the required information. And if you're not sure what the mandatory format of the Federal Register is, and you don't want to spend the time to go look it up, you don't have to, because we've prepared notice templates for you that adhere to that mandatory format of the Federal Register, as well as indicate all the required information. This is important because you want to be sure that you're using the most recent notice template that we have available, again, on our website. You can find it under Law and Policy. There's a link to a templates page that includes all of our notice templates. The Federal Register in particular has very specific formatting requirements for headings, spacing, margins. And so to ensure that you're meeting all of those requirements, we really want you to be sure that you're getting our most recent updated notice template. It will ensure that the process is quicker and that we don't need to return your notice for changes or edits. You will see that that's the next piece of the slide here, is that within 21 days after receiving your notice, again, receiving through that info box email, I will either approve the notice for publication in the Federal Register if it meets those format and other requirements, or I may return the notice to the museum, federal agency, if it does not conform to those requirements or the formatting. And then there'll be a 14-day response period for the museum or federal agency to resubmit the notice. You really don't want your notice to be returned to you. You want to ensure that you're including all of the necessary information. And again, the best way to do that is by using our notice templates and filling them in as instructed. As we go through the presentation today, I'll actually share with you those templates themselves and talk a little bit more about the specific information that's requested in each template. So to dig into some of the specifics here, first I'm going to talk about the requirements for human remains and associated funerary objects. This page is from the Act itself. These are actually the sections of NAGPRA itself that relate to human remains and associated funerary objects. And in particular, these are the places where the notice provisions come from in the Act itself. So we're first going to talk about what's required after an inventory is complete. And remember, that's the notice of inventory completion, is that notification requirement. And then we'll talk about options that come after the notice is published. Again, this is language that comes directly from the law itself. The requirement after an inventory is complete is that within 6 months, a museum or federal agency must notify Indian tribes and Native Hawaiian organizations by identifying each Native American human remains or associated funerary objects, those that are clearly identifiable as to tribal origin, and those that are not clearly identifiable but reasonably determined to be culturally affiliated based on the circumstances surrounding their acquisition. Again, I think you can tell that this is the language that comes directly from the Act itself. We'll talk a little bit on the next couple of slides about how the regulations have clarified some of this language. But the language in the Act requires museums and federal agencies to make this notification to Indian tribes and NHOs. And it requires certain information be provided in that notification. And a copy of each notice is published in the Federal Register by the Secretary of the Interior. Again, you can see the citation at the bottom of the page there that shows you where in the Act you can find this language exactly. The Act also includes options or discretionary actions after an inventory is complete. And those discretionary actions are on the part of lineal descendants, Indian tribes, and NHOs. So you'll see here that after an inventory is complete, and once that 6-month notice is published, then Indian tribes or NHOs may, and this is a may because it's at their discretion, may request the repatriation of culturally affiliated human remains and associated funerary objects, or an Indian tribe or NHO may request repatriation of human remains or associated funerary objects where there is no cultural affiliation. They may request repatriation by showing cultural affiliation by a preponderance of the evidence. This is a section of the law that has often been misinterpreted or misunderstood when it comes to the concept of preponderance of the evidence in particular. And so I wanted to be very clear here that in the language of the law, if cultural affiliation is determined and published in that notice, then all that's required after the inventory is complete and the notice is published is for a tribe or NHO to request repatriation of culturally affiliated human remains. Where cultural affiliation has not been determined and the notice publication indicates that no cultural affiliation has been determined, cultural affiliation can still be shown and a request for repatriation can still be made. And again, this is the language from the Act itself. We'll talk in the next couple of slides about how the regulations lay this out as a step-by-step process. So again, going back to my chart here of the 3 different processes and the 3 different notices, here we're talking about the middle piece. Repatriation of human remains or human remains or associated funerary objects, and the notice of inventory completion requirements. So I just want to be clear again, we're talking here about the middle line of this table and the requirements for a notice to identify cultural affiliation of human remains or associated funerary objects. So we've talked about what the law says, and now I want to talk about what the regulations provide. And the focus here will be on step 5, submit a notice, as well as a little bit of step 6 in receiving and considering requests. So step 5 of the NAGPRA regulations, again, the revised regulations, if you're not familiar with where to find them, you can find them on our website. This section in particular is that we're talking about here with human remains and associated funerary objects can be found in section 10.10 of those regulations. And step 5 requires submission of a notice. What this slide shows is information that I've presented in a number of these webinars before, organized by what is required under the check mark, what is not required under the X, and where there is discretion or option for a museum or federal agency under the question mark. So what is required by a notice in the regulations is that the information and determination of cultural affiliation from the inventory must be in the notice. The regulations also require that the notice identify the total number of individuals and the number of associated funerary objects. There must be contact information provided in the notice. And the notice must provide a date when repatriation can occur, which is, again, that window of time, the 30 days after notice publication, when repatriation may occur. What is not required in a notice are specific site numbers or accession numbers. Now, we often see that museums prefer to include those kinds of identifications in a notice, and that's okay. But I wanted to be very clear that there's not a requirement for a notice to indicate what site numbers or accession numbers or collection number is associated with the human remains in the notice. Likewise, if you've read notices of inventory completion before, you may see that there is very detailed information sometimes included about the human remains involved, and that can include the age, sex, or other detailed information about the human remains themselves. But that is not required. And I'm specifying here the information that's not required because this is often what we see submitted in a notice, or rather, it's what we hear is delaying the process of completing the notice. And so we wanted to be very clear that this is not required. It doesn't mean you can't include it if the museum or the consulting parties want that information provided in a notice. It can certainly be there. But certainly there's no requirement for this information or the detailed information to be provided in the notice. Lastly, where there is discretion in the notice and the content of the notice is with the organization of the notice and the level of detail. There is no requirement in either the regulations or the act itself that requires different paragraphs in a notice for each site. It's not there. It doesn't exist. Yet many museums and federal agencies, and over the course of the last 35 years, a large number, probably the majority of notices that have been published, include that level of organization. They're organized usually by that site number, maybe by accession or collection, or in some cases, excavation. And that level of organization is up to the museum or federal agency in consultation with the tribes. It is not, there's no requirement there for site level information to be the method of organization. And in fact, I would encourage any museum or federal agency to discuss the organization of a notice with the consulting parties, because you may find that there are other methods of organizing the information that are better suited either to the collection or to the tribe and consulting parties involved. So again, I wanted to be very clear here about what is required versus what's not required, and then where there are options. And one of the options there is, of course, the level of detail that's provided in the notice. The level of detail that is required in the notice is an abstract of the information from the inventory. So the details for what is required in an inventory can be found in the regulations in step 1. And those include information like the geographical location and the acquisition history of human remains and associated funerary objects. But that level of detail is not required to be put in the notice itself. While it is required, if available, to be in the inventory, that level of detail is not required in the notice. And this is an important distinction because it may be that there's certain information that tribes, consulting parties, or even the museum would prefer not to be put in a public notice, but is contained in the inventory. So again, you can find the information on the detail that's required in an inventory in step 1 of section 10.10 of the regulations. We lay out there the 6 different items that are required if that information is available. In the notice, the requirement is to abstract that information or to generally describe that information from the inventory, but without necessarily that detail. And that's where you get to this discretion of a museum to decide how to organize or what level of detail to include. We have examples of many notices, again, not the majority of notices, but plenty of notices where the level of detail may be very broad in terms of geographic location. Maybe well, not maybe, I know that there are examples of notices that include information on a state level, and even that multiple states across multiple states, the number of human remains and funerary objects that are in a holding or collection can be described that broadly. And that's fine. If that's what the museum prefers, if that's what the consulting parties prefer, and everyone agrees on that detail, or in this case, the lack of specifics, is fully acceptable. So how long should it take to draft a notice and submit that notice to the National NAGPRA program? Well, again, the regulations require, and the law also requires, that 6 months after completing an inventory, a notice is submitted. So it can't take longer than 6 months. That's the requirement using the check mark. The question mark are, again, that discretion or the options here for how long it might take. Certainly, many museums and federal agencies, as well as Indian tribes and NHOs, like to review and draft notices during the consultation process. That's perfectly acceptable. And in fact, many museums and federal agencies submit notices with completed or updated inventories. So the bottom line here that I'm telling you all is that it doesn't have to take 6 months. It can go a lot faster than that. But the requirement is to complete this within 6 months of completing or updating an inventory. So when I say that it could happen fast, I mean that if you have the information from the inventory, you should be able to fill out the notice template fairly easily. There should not be a lot of time needed to fill out our template. So what you're seeing here is our current template for a notice of inventory completion for culturally affiliated human remains and associated funerary objects. The first page of the template includes instructions. And what we've done in this new version of our template is try to consolidate all the information you need to have to plug into the template on this first page. And in fact, we've gone so far as to number the pieces of information that you need to plug in to the notice template. And so that's here on the screen where it asks you to insert 7 pieces of information. And I think hopefully as you look through that list of the required information in a notice, you'll see that it could be fairly easy to gather that information. The first piece of information is the name of your museum or federal agency. Hopefully that's an easy thing for everybody to gather. The second item of information that's required is the name of the authorized representative. Again, hopefully your institution has already identified who that contact person will be. The third and fourth items in the notice relate to those numbers of individuals that are identified, the individual human remains identified in a reasonable manner, and the number of associated funerary objects, or a statement that there are no associated funerary objects present. After that, a brief description, as I mentioned, a brief abstract of the information that's from the inventory itself, and then the determination of cultural affiliation, either one of 2 options for cultural affiliation here, either clearly identified or reasonably identified. And we'll talk more about those options in a minute. And then the last piece of information that's required are the names of the Indian tribes or NHOs that have cultural affiliation. We ask that you not make changes to the headings or other sections, especially to the date in brackets. That date in brackets is what instructs the Federal Register to calculate a date upon publication. And again, remember that the spacing and formatting of this document is precise to the requirements of the Federal Register. So while I understand that you may look at this and not like the fact that there's a 1.5 inch margin on the left, you need to keep that in place because that's the requirements of the Federal Register. Likewise, perhaps you are not used to formatting your documents as double spaced, but that is the requirement of the Federal Register. So it's very important that you try to keep to the formatting so that it doesn't cause any delays in getting your notice published. We ask that you remove the instruction page as well as any highlights or italics or braces. That's where you fill in the information. We also ask that you verify all of the information in your notice, especially numbers or addition. And when we say addition, we mean arithmetic. And this is critical because we often find that in filling out a notice template, perhaps a museum or federal agency doesn't quite double check their math. And this is so important to be sure that the numbers that you're providing of human remains and associated funerary objects in the abstract section equal the total number at the end in the determination section. We'll talk about that in a minute, but I can't tell you the number of notices that we get where the math is wrong. And you may have heard me say in other cases that NAGPRA is not an accounting exercise, and that's true. NAGPRA requires, the regulations and the law itself requires that you identify a number of human remains and associated funerary objects, but that number must be identified in a reasonable manner. There's not a requirement for an accurate accounting as maybe some of you might envision in coming up with that number. So while NAGPRA is not an accounting exercise, you do need to have good arithmetic, and that's just logic, because we want to be sure that the numbers that you're describing in the notice equal the total numbers in the notice. And so it's very important that you do a double check of your math. I highly recommend that you have somebody else double check your math. We here at the National NAGPRA program often rely on each other to be sure that we're calculating things correctly. And it's important that you do this check because the National NAGPRA program does not review or validate the content of your notice. You are responsible for the content of the notice, and you are responsible for any errors that might be in this notice. So please be sure that you're double checking both the information and the arithmetic. Again, on the instruction page, it indicates to send the notice to the manager of the National NAGPRA program by email. And again, that email address is nagpra_info@nps.gov. And then the instructions again for how long after you submit the notice, I have 21 days to review and approve it. And then we estimate that the notice will publish then 5 to 10 days after approval. And we will send you an email once the notice is published. So looking at the templates themselves, you'll see on the other side, the template with the yellow highlighted information in braces. And that is where you plug in the information, those 7 pieces of information that are on the instruction page. Again, 1 and 2, hopefully very easy. First page done. Second page, number 3 is the number of individuals. Again, should be taken directly from your inventory. Number of associated funerary objects, again, taken from your inventory. And then a list of the type of object or group of objects. So for example, pottery sherds, tools, beads, buttons. Whatever can broadly describe the number of associated funerary objects or the type of associated funerary objects that you're including in the notice. And that is important, again, to provide that due process, that transparency, so that if someone else does have an interest in these human remains, they can identify that interest based on the information contained in this section. So that's where number 5, the brief abstract of information from the itemized list or the inventory, that is updated as appropriate. So that can include the geographic location, the acquisition history, or other information about the human remains or associated funerary objects that would allow someone else who hasn't been involved in consultation or communication about these human remains to identify that they have an interest or they might have potential rights. And so in those cases, then, that's what you're trying to capture here, is that broad level of information. And again, the level of detail here is up to the museum or federal agency in consultation with tribes. There is not a requirement that certain types of information be included. General information, where it's available, should be provided in this abstract section. Quite often we see notices, especially notices of inventory completion, where there's a lot of detail provided in this abstract section. And that's up to the museum or federal agency. You can choose to provide that level of detail if you want to. You're not required to. And I will say that my advice is to be very cautious about how detailed you are in this section, because the more detail you provide, and the more chances are that you're going to make a mistake. And we often see that it is the level of detail in this section where errors are made, or information is misrepresented, that if the museum had stepped back and maybe thought more generally about this section, they could have avoided those mistakes or those errors. And I think that something that's hard maybe for some people to wrap their heads around, because this is a publication, is that this is a public notice. This is not a dissertation. It's not an article. It is not a academic work product. Rather, this is a legal notice published in the Federal Register. And as such, brevity is important, both for the museum and federal agencies' needs to ensure that you're providing accurate information, but also for us in the National NAGPRA program, because the longer your notice, the more expensive it is to publish. And lastly, for the Indian tribes and NHOs, and perhaps most importantly, the level of detailed information here can be incredibly sensitive and very important to either have included or to exclude. And so there may be reasons why consulting parties in particular would like certain information included, but also might prefer certain information not be included, which is why I highly encourage consultation to include discussion of what information should be in the notice. The next section refers to cultural affiliation. Again, item number 6 is where you choose one of two options in the cultural affiliation template for cultural affiliation decision. So again, there are two options for a decision on cultural affiliation. The first is that cultural affiliation is clearly identified. The second option is that cultural affiliation is reasonably identified. Now, that decision must be also in the inventory. So the first place that decision is made is in completing the inventory. All you're doing here is reflecting that decision that was made in the inventory. The final section of the notice, or the final information piece that you provide, is on the determinations. And this is where the arithmetic comes in, because we ask you to total the number of human remains in the notice, as well as the total number of associated funerary objects in the notice. And then the final piece of information that is included is the list of culturally affiliated Indian tribes in alphabetical order. And that alphabetical order is dependent on the official list of federally recognized tribes that is published in the Federal Register. That list of federally recognized Indian tribes published in the Federal Register is published annually. And you want to be sure that you're referencing that official list, both for the alphabet, but also for the official name, and also to be sure you're getting it correct. Because again, it's incredibly important to pay attention to the specific details here of the tribes and the tribal names as they are officially represented by the Secretary of the Interior through that official publication of the tribal name. It's in that list that, for example, you'll find when tribes' names change, that will be reflected in that list. And sometimes the change is minor. We've seen over the years, many tribes prefer to have their official name not include their state. Just, again, a small change. But in other cases, and in fact, most recently, a tribal name has changed from a previous name to a more culturally appropriate tribal identification name. So it's very important that you're consulting the most recent list of federally recognized tribes and that you're using that name. It's very easy to copy and paste that name from the Federal Register list into your notice itself. And we have a link to that Federal Register list on our website. It's under our consultation resources, which is under getting started. But again, if that's not something you have bookmarked and you're writing notices, I would highly encourage you to have that list bookmarked and be sure that you're looking for the update every year. The most recent list was updated in December of 2024. So you want to be sure that you're using that list. Okay, so again, looking at the overall process, I wanted to include this table, and this table is something that we provide in our Steps to Repatriation document. You can find that on our policy page. It's a document that we created that gives in, well, sort of bright colors, very blue colors, the steps to repatriation and a brief description of each step. It's intended to be a quick guide to the process. And in fact, I've got mine here hanging on my bulletin board so that when I'm working with a museum or federal agency or tribe, we can talk through exactly which steps we're in. And so a part of that document, that Steps to Repatriation document, is this table, which gives a time frame for repatriation of human remains. And again, we're looking here in the middle of the steps to submit a notice. And I just wanted to again lay out that there is discretion here on the part of the museum or federal agency in how long this process takes. Maybe it will take you more than a day to complete a notice of inventory completion template. That's acceptable. I can understand that, especially if there are levels of review, especially if you'd like somebody to check your math, you might need more than a day to complete that. But the reality is you could move very quickly from completing the inventory to submitting the notice of inventory completion. And so that's where we get the shorter timeline. The longer timeline, of course, is you can take up to 6 months to complete that the notice of inventory completion and submit it. And again, I just wanted to provide this table in showing the difference between the shortest possible timeline here, which is 42 days to complete the process for human remains and associated funerary objects, and the longer timeline, which could take up to 3 years to complete this process. And so there's a lot of discretion in that 6-month period for submitting a notice. Okay, the last thing I wanted to share about the notices of inventory completion is, of course, go read some. If you've never prepared a notice of inventory completion, your first task should be to read some. And I encourage anyone actually to read notices of inventory completion because they're an excellent education in sort of the NAGPRA process and the reason for NAGPRA. Because each of these includes that abstract section that talks about how these collections were made, when the collections were made, and in some cases, who made the collection. And then the resulting cultural affiliation for those human remains can be found in the notices themselves. So every notice that's published in the Federal Register, every notice of inventory completion is posted to our website. They're posted here in real time, so as it publishes in the Federal Register, the day it publishes in the Federal Register, we will send an email to the museum or federal agency that submitted the notice, and it will be posted to our website. So I wanted to switch back and here talk about repatriation of unassociated funerary objects, sacred objects, and objects of cultural patrimony. Now, remember that there are two different processes. One process for human remains and associated funerary objects, and a separate, different process for unassociated funerary objects, sacred objects, and objects of cultural patrimony. And as a result, there are different notice types. What we've just been talking about are notices of inventory completion, which are only for human remains and associated funerary objects. We're going to switch here and talk about the other kinds of cultural items covered by NAGPRA, which are included in a notice of intended repatriation. So we're switching gears here. You will see that there is some similarity, but there are also some very particular differences. So it's very important to know which kind of object or collection you're talking about, to know which process you need to follow. And this is often a point of confusion. And often, if you come to us with a question, our first question back to you will be, well, are we talking about human remains and associated funerary objects, or are we talking about other cultural items? Because that will determine then which step we proceed through, what the process is. And this is all tied back to the law itself, because there are different sections of the law and different requirements in the law, whether we are talking about human remains or other kinds of cultural items. So in looking at the law, again, this is the language or the outline of the law itself, and the requirements for other cultural items or unassociated funerary objects, sacred objects, and objects of cultural patrimony can be found in 25 USC 3004 under summary. Includes what is required after a summary is compiled, and then what the options are after a summary. So much like we talked about the law and the language from the law itself, for human remains, I've prepared these slides to talk about the language from the law related to other cultural items. So once a summary is compiled, there are some requirements after that summary. One requirement is consultation, and probably one of the biggest differences between human remains and associated funerary objects and other cultural items is when consultation occurs. Consultation, of course, is required for human remains before completing an inventory, but here consultation comes after compiling a summary. The requirements after compiling a summary are to consult when requested, also to share information when requested. And because of the general nature of a summary, updates are not required for a summary, because a summary is not that level of detail that's required in the inventory of human remains. So generally, an update to your summary is not going to be required. And then, of course, after completing a summary, a museum or federal agency must receive and consider requests for repatriation. And again, this is sort of, in this case, I've abstracted the language from the law itself. There is a lot more discretion after a summary for Indian tribes and NHOs to make requests for repatriation. Where cultural affiliation has been identified in a summary for unassociated funerary objects, sacred objects, or objects of cultural patrimony, where the summary says clearly these belong to this culture group, then the requirement is for the tribe or NHO to make a request for repatriation of those objects. Where perhaps that is not as clear in the summary, then that's on the next slide. But the requirements of the law is where the summary has a clear cultural affiliation for any kind of object. What is required is that the tribe or NHO make that request for repatriation. There's an additional piece of a requirement here in that request, which includes a discussion of right of possession. And we'll talk about that more because we hope that we've clarified that requirement a bit in the regulatory language. If cultural affiliation is not clearly shown in the summary itself, but cultural affiliation can be shown, then Indian tribes or NHOs may still make that request for repatriation, again, of cultural items. We're talking here about sacred objects, objects of cultural patrimony, or unassociated funerary objects. And the law provides some additional detail, really looking at who can make those requests and related very much to the definition of the objects themselves. So again, sacred objects can be requested by a tribe or a Native Hawaiian organization. Sacred objects can also be requested by lineal descendants. But based on the nature of an object of cultural patrimony, those can only be requested by a tribe or an organization. An object of cultural patrimony could not be requested by a lineal descendant because the two definitions there of a lineal descendant and an object of cultural patrimony sort of negate each other. So again, the language of the law sort of lays out these particulars about those requests for repatriation. And again, this is the discretion of the Indian tribe or NHO to make that request after a summary has been compiled. Again, I copied this same slide to try to get at what we're talking about here. So here we're focused on the last line of the table. Repatriation of unassociated funerary objects, objects of cultural patrimony, and unassociated funerary objects. And those are in a notice of intended repatriation, and they identify that a request for repatriation has been received and accepted. So again, the steps to repatriation here were focused on, in this case, step 6 of submitting a notice. And you'll see that another critical difference in the process for cultural items versus human remains is that the request for repatriation comes before a notice of intended repatriation. So for other cultural items, first is a request, then a notice. Whereas for human remains, the notice comes before the request. It's one of the most critical differences between the two processes, and it can be difficult to remember, which is why we tried to make these clear step-by-step process where you can see the request that comes before the notice when we're talking about unassociated funerary objects, sacred objects, and objects of cultural patrimony. Yet again, another reason why you need to clearly know what we're talking about before we answer a question of how to proceed. So what's required in a notice of intended repatriation? An abstract of information, again, is required. The total number and brief description of the cultural items is required. Who is making the request? So the name of the requester is required. Same contact information as well as the date that repatriation may occur. What's not required? Very similar. Site numbers, accession numbers, or detailed information about the objects. And I would add to that detailed information about why the objects meet a category. None of that is required. All that's required is an abstract or a brief description of the objects themselves. There's not a threshold level of detail that's required about the object to be published in a notice. Again, how a museum or federal agency chooses to organize its notice of intended repatriation and the level of detail provided is really up to, the museum or federal agency. But again, I would encourage that consultation is very important in deciding what that level of organization and level of detail might be. How long should it take to submit a notice? Again, here, a notice of intended repatriation. It must be completed 30 days after responding to a request for repatriation. And again, should be very simple to fill in the template. Again, we would encourage any museum or federal agency or tribe or NHO to actually discuss the content of the notice during consultation. And certainly, there's no need to wait 30 days to submit a notice of intended repatriation. It can be submitted immediately after responding to a request. You'll see the template here looks very similar, although there are some differences. In this case, there are 6 pieces of information that need to be filled in the template. Again, we've provided that instruction page, which much of that is the same. We're going to ask you to plug in the same kinds of information with, again, a few variations. We're going to ask that you not make changes to the headings or the formatting, and you submit this notice, again, to the National NAGPRA program by our email, nagpra_info@nps.gov. The main differences here come from identification in the abstract section of the kinds of objects that are included. And again, for each different kind of object, you would include the number of unassociated funerary objects, the number of sacred objects, or the number of objects of cultural patrimony. Now, in some cases, a notice may contain some of each type. And so you might have 3 sentences here that include the different kinds of objects that are being repatriated, and that's fine. And there may be cases where there might be more overlap between the kinds of objects. You know, we have very frequently seen that the number of sacred objects that a single object may be both a sacred object and an object of cultural patrimony. And so there might be one object that meets both of those definitions. Similarly, we've had a number of cases where one object actually meets the definition for all 3 kinds of objects. And again, acceptable, and you would just modify the language here to clarify that while it's one object, it is an unassociated, that one object is an unassociated funerary object, a sacred object, and an object of cultural patrimony. Completely acceptable way to do that might require a little bit more grammatical changes here. And certainly in the next section, the determination section, you would want to clarify how many objects meet those specific definitions. In the determination section, we have actually repeated the definition of those objects. And again, the determination section is just that. It's the museum or federal agency saying that we have determined, based on a request, that this many objects are unassociated funerary objects, this many objects are sacred objects, and so on. And then the last bullet point here again refers to the Indian tribe or Native Hawaiian organization that has made the request for repatriation, and that name then is included here in the final bullet point. Again, same request that you carefully check the list of federally recognized tribes in completing that bullet point. So again, in looking at the timeline here, we're talking about step 6, and you could see in the shorter timeline where the process moves very quickly. You could be submitting a notice of intended repatriation as quickly as 7 days. Or if the process takes longer, and again, acceptable for that process to take longer, it could be up to over 300 days before that notice is submitted, depending again on the process, the amount of time required. It can be as quick as the shorter timeline or might take longer. And again, notices of intended repatriation can be found on our webpage. You can read them. You can take a look at an NIR, a notice of intended repatriation, and compare it to a notice of inventory completion to really understand some of the differences between those two kinds of notices. All right, so this last slide and the last section here of the presentation, and then we'll move into questions. So please, if you have questions, I'll open the Q&A in just a minute, and you can pose your questions there. What happens after a notice is published? Well, again, and perhaps I should have moved this earlier because I think that we've kind of talked about this already. For each of the different processes, after a notice is published in the Federal Register, a different step happens. And so looking here at the middle line where we're talking about human remains and associated funerary objects, again, as I've described previously, after a notice of inventory completion is published in the Federal Register, it is at that point that an Indian tribe or NHO would make a request for repatriation, and the museum is obligated to receive and consider that request. On the other process, the process for other cultural items, after a notice of intended repatriation is published, the next step is to send a repatriation statement, that final step in the process. Again, just an indication of the difference here between these two processes. And actually, let me go back and say that that piece of what happens after a notice is published is in each notice template under requests for repatriation. So that final piece of the notice says what happens next. So what happens after a notice of intended repatriation is published in the Federal Register is here on page 3. After that notice is published, additional requests for repatriation can be submitted. And they can be submitted by anyone who has an interest in those objects that is not identified in the notice. But repatriation then to that individual identified in the notice can occur after publication in the Federal Register after that 30-day window. And it's a little different than what you'd see in the request for repatriation section for a notice of inventory completion because of that requirement for a request for human remains. So again, there is a difference in the notice type and in the language of the notice because these are two different processes. All right, the last slide that I have for you is probably one that many people ask questions about, maybe not daily, but maybe weekly. What happens if there's a change? What if I publish my notice and something changes? And this is really critical to consider. And again, you can find this information on our website, on our notice page. If there are additional human remains or additional cultural items identified after a notice is published, then the museum or federal agency must start over with step 1 for those newly identified human remains or cultural items. This ensures that there's adequate consultation and notification before the process continues. Now, if those additional human remains or cultural items are not new, if they are pieces or parts or fragments of previously identified human remains or cultural items, then they can be transferred. A new notice is not required if there are additional pieces or fragments. And so it's critical if something's changed that a museum or federal agency decide if what is changed are new or parts of previously identified human remains or cultural items. And this is a key step and one that I should be consulted on because again, there may be a lack of clarity. It may not be very clear. And there is some discretion here on the part of the museum or federal agency in how it determines if these are new or not new human remains or cultural items. And maybe the way to explain that is to remember that in a notice, the number of human remains is identified as at least the number, right? So there is at least one individual from this site in the collection. Well, what happens then if you later down the road identify that actually there probably are two? Well, if there's at least one, then that includes two. If there are at least 5, that includes 6. Again, it's up to the museum to make that decision, the museum or federal agency, about whether something is an additional, a new human remains or cultural items, or if they were previously identified in a notice. And that makes the decision here about whether a new notice is required. So again, just an important piece of the puzzle here to kind of consider and certainly to consult on. Now, there is one change in a notice that may require a revision to a notice, or what we call an amendment to a notice. This is entirely optional, and we would say, that it is only if the consulting party wants this change made that we would publish that amendment notice. And that is when there is a change in cultural affiliation or in the requesting parties. So where there's a change to cultural affiliation, we will allow an amendment notice to be published. And we have a template for that. Again, it's on our notice page under compliance, notices and statements. And that can be used to add or revise the identification of the lineal descendants, Indian tribes, or NHOs. But again, it's important to remember that that's optional. It's not a requirement, and should only be done if that's the request of the consulting party. So again, where there's a change in cultural affiliation, it's optional to publish that in the notice. It is not, it's optional to publish an amendment notice. It's not required, because if after a notice is published and someone else comes forward and says, well, actually, we want to request repatriation of these, then the museum or federal agency has to evaluate that request. The museum or federal agency has to identify if this is a competing request or a joint request. And the museum or federal agency can proceed to the repatriation statement, even if the notice published cultural affiliation is different than the resulting repatriation statement. That's acceptable, and that's actually a part of the process here. Okay, so I'm going to turn on the Q&A. I see that I got a few questions in the chat, and I'm going to try to answer those. So you don't have to put your questions in the Q&A. I will go ahead and answer those. Let me stop sharing. And again, I ask that you please put your questions in the Q&A. I've turned that on. I've also made it so that you can upvote a question, meaning that if somebody asks a question and you have the same question, you can thumbs up, and that will put it to the top of my queue in case we aren't able to answer all of the questions. All right, and again, our reason for having you put your questions into the Q&A is because, one, we may not get to them all, and two, it gives us a better way to track the questions that we've received and the questions that we've given answers to. And I'll add, it relieves me of the burden of trying to answer everything, because I have a wonderful team that works with me. You may be used to just seeing me on the screen, but we have a well, not a large, but we have a team. We have a team of NAGPRA staff here at the National NAGPRA program, and they can assist in answering questions if they come through the Q&A. All right, so I promised first to start with the questions that I got in the chat. I think I tried to answer most of them. We talked about the level of detail that's required in an inventory. You can find that in step 1 of section 10.10. There is confusion always about the two kinds of notices, and I hope that I clarified the difference in which type of notice depends on what kind of collection you're talking about. And I apologize if I wasn't clear in my presentation always which one I was talking about. I try very hard to be clear and to include a reference on those slides, but I may have missed that in a few places. But again, a notice of inventory completion is for human remains and associated funerary objects only, while a notice of intended repatriation is for other kinds of cultural items. And then the last question, what's the process for changing affiliation in the inventory? The question is, what's the process for changing affiliation listed in the inventory in the Federal Register? Well, again, the inventory is one document, and the notice of inventory completion published in the Federal Register is a different document. And if cultural affiliation changes after publication of that notice of inventory completion in the Federal Register, I talked through that you can amend a notice if that's the preference of the consulting parties, but it is not a requirement. You can track that change in cultural affiliation through the repatriation statement and certainly in a response to a repatriation request and through the other steps that come after that notice is published. Okay, I'm gonna switch over. Oh, there was one other question that I didn't quite answer, and that was about the term lineal descendant and whether that applies only to Native persons or does it apply to descendants of any ethnic group. I would refer you to the definition of lineal descendant that's in the regulations. The definition of a lineal descendant is particular, but the requirements are that there be a living person, and the ethnicity or identification of that living person is not specified, meaning that the living person does not themselves need to be, does not need to identify as Native American or be a member of a tribe in order to be a lineal descendant. What's required is that that lineal descendant can trace their ancestry to the Native American individual whose remains or cultural items are being requested. So again, it's about the living person's identity and the person whose remains or objects are being requested can be identified. So hopefully that helps. I'm going to sort again by upvotes and go with the top question. All right, with the museum statements, okay, so topic change. This question is not about notices. This question is about museum statements, which are a requirement under the regulations in section 10.8. And the question is, with the museum statements many federal agencies received in January, the responses federal agencies are working on by July, is that original museum statement considered an itemized list? If not, is it now on the federal agency to compile the itemized list and to follow the timelines for NICs or NIRs? It's a good question and one that I can't answer. The federal agency that says that is agreeing to possession or control has to decide what level of detail is needed in either the itemized list to initiate consultation or in the summary that would be required to be compiled. So the answer to your question is it's up to the federal agency. And it will depend a lot on the information that comes in that museum statement, and certainly on the policies and procedures of the federal agency itself. But the requirement is that a federal agency, once it is aware that it has possession or control of a holding or collection, has obligations for reporting that holding or collection either through the summary or the inventory process. And adhering to the timelines for both. And to, as a reminder, the requirement to sorry, it's Friday. The requirement to compile a summary is 6 months after locating or acquiring possession or control. So 6 months after possession or control is determined, a summary is required. It is 2 years after acquiring possession or control of human remains that the inventory must be complete. So 6 months for the summary, 2 years for the inventory, but remember, completing an inventory requires consultation. So that 2-year time period also includes consultation. And we would encourage you to work on the itemized list as quickly as possible, because that will get you to the consultation phase. Okay. The next question that is at the top of the list is, recent executive actions have changed the process for notice approval, and there was a lengthy delay after January 20th. Is the National NAGPRA program now able to approve notices within the regulatory deadlines so that we're not waiting months for notices to be approved and published going forward? Thanks for the question. Let me clarify a little bit. This is related to notices. And as I mentioned, I think at the last monthly webinar and certainly in other public forums, we did have a short-term delay in publication of our Federal Register notices. This is a very typical delay that occurs every time there is a change in our leadership within the federal government. Sometimes the delay is a little longer than others. This delay was slightly longer. But that delay, I want to stress, was not what was related to a secretarial order that was issued, which just required an additional layer of review and approval before publication could occur. And so we did get through that additional approval requirement. And as hopefully you noticed, we published 96 notices this week. So all the notices that had been waiting for that approval for publication were approved last week. And thanks to the heroic efforts of Lori Jennings in our office, all of those were sent over to the Federal Register and were published on Monday, Tuesday, and Wednesday. It was a lot, certainly the most that we've published in any 1 week since 1992. But it signals that the process is now in place. And so this short-term delay is now no longer going to occur. We fully expect notices to resume their regular cycle of approval for publication. What I want to stress that's maybe a little bit different than the question asked is that the regulatory requirement is a 21-day period for me to approve the notice for publication. The time that it takes from when I approve a notice for publication until publication occurs varies. And it varies for a lot of reasons. It varies because of the approval process that is required or has been required in the past. And there were times in the past, I've been with the National NAGPRA program for 13 years, and there were times where that period of approval for publication could take months. Luckily and thankfully, that has not been the case for the last several years. And as the recent last 2 months showed, it changes. But generally, we expect that from when I approve a notice to when it publishes, somewhere between 5 to 10 days. That's our current estimate. Again, it's going to depend on the Federal Register. Sometimes the volume of the Federal Register means they need to delay a day or two before they can publish. Weekends and federal holidays impact the 5 to 10 day estimate. But right now, our estimate continues to be 5 to 10 days after I approve a notice for publication of a notice. And I'll mention that you can track that process, that timeline. So I sign a notice, and that date is reflected in the Federal Register, and that date will differ from the date of publication, but it is that time period between when I sign a notice and when it publishes that is our kind of approval process. All right, a question that digresses, but is actually just sharing some news that a TIPO office this week has been getting requests from agencies for review and response required in 7 days instead of what used to be a 30-day review. And will this be the standard going forward? There's no review timeline for NAGPRA, so I think that as the comment to your question says that this could be probably related to a different kind of review, maybe through the National Historic Preservation Act and Section 106, and a change in timeline there. And that could be related to changes through other executive orders. All I can tell you is that I can't answer your question about a standard going forward because it's not a NAGPRA standard. There's no review timeline associated with any NAGPRA action on the part of tribes. So let me say again, NAGPRA does not impose timelines or deadlines on Indian tribes. The deadlines and timelines that are imposed by NAGPRA and by the regulations are on museums and federal agencies. Indian tribes and NHOs have discretion in how they decide to engage in the process. Now, keeping in mind that there are timelines like the 30-day window, that if a tribe is not represented in a notice, that is the window by which they need to come forward and make a request. So that in that way, there are timeframes, but not timelines or deadlines. Thank you, everyone, for commenting and adding a link to an ACHP, the Advisory Council on Historic Preservation announcement related to Section 106 review timelines. And I believe that you can see questions that have been answered. Let me double check the settings. Yeah, attendees can view all questions. So you can see questions that are open as well as questions that have been answered by looking at the Q&A. And that will give you the link that was shared. Okay, another question with the most up-to-date votes. Let's say you publish a more general NIR or NIC, Notice of Intended Repatriation or Notice of Inventory Completion, that only states you have human remains, cultural items from a specific county. If you find additional collections from that county that have not been reported to tribes before an inventory or summary, would you need to publish a new notice, or could those new collections be considered under the previously published notice? Thanks for the question. And the answer is you, museum, get to decide. You, the museum, must evaluate the information you have about those additional collections. And you, the museum, must decide if those are new human remains or cultural items, or are they previously identified in an inventory summary or notice. Now, you should make that decision in consultation with Indian tribes. So based on your decision there about the collection and what it represents, you would either begin the process again at step 1, whichever process that is, and that would include consultation and notice publication. Or if they were previously reported and if you decide that this collection is part of what was previously reported, previously published in a notice, you can proceed to transfer. So again, it's a decision that the museum or federal agency must make, and that decision should be made on the information that you have about the additional collections. So I hope that answers your question. I know it's not a yes or no answer. And like most answers under NAGPRA, it is really depends on the information that you have, how you decide to move forward. But the important part is that you decide which path to take, because that again will trigger deadlines or timelines accordingly. Okay, the next question is, hypothetically, if an institution has a site that has cultural items that were previously repatriated and an NIR was published for those, but a new type of cultural item, example, sherds, ceramic sherds, which were not described on the previous NIR are found, and the institution consults with the appropriate tribal partners who the previous cultural items were repatriated to, would the institution be able to transfer the new cultural items without amending the NIR if the tribal partner is okay with it? Well, first of all, let me just clarify that the choice here is whether you start from step one or you transfer. There's not a process by which you would amend the previous NIR. Let me say that again. Your choices are to start with step one. In this case, with cultural items, you would be preparing a summary, or transfer. So it would depend. The answer is the same as the last question. It depends on the information about the new cultural item, and it is up to the museum to make that decision. The museum needs to make that decision, as I said, in consultation. Reasons why a museum may prefer to go back and start at step one would include if this cultural item is unique or very different and might change the cultural affiliation of the object or who is interested in requesting the object. In that case, there's a benefit to starting with the step one and compiling the summary for this object and proceeding. Alternately, I'll say that starting with step one, in either case, either the case of human remains or other cultural items, does not mean a lengthy process. It means 42 days, starting with step one. You can move as quickly through either process, through either timeline in just over a month. So while your choices between starting with step one or transfer without amending, without any other requirements, it doesn't mean that this needs to be an exaggerated timeline. And I want to stress that because it's a challenge for us at the National NAGPRA program when people talk about wanting to avoid the full NAGPRA or the whole NAGPRA, because we have worked so hard to try to show how simple and streamlined this process can be and can occur in as little as 42 days in either case. So again, your choice to start at step one or to transfer doesn't necessarily mean an extensive timeline. Rather, it means that you need to decide based on the information you have, what is best for you, the museum, and your decision-making process, and certainly what is the preference of the consulting parties. Okay. The next upvoted question is, can you speak to the reason why summary items and inventory items need to be addressed separately? Any possibility that future regulatory changes could combine the two and be handled as one type of a notice? Thanks for the question. This is one of my favorite questions to answer, because the answer to this question is in the legislative history. And as we are out of time, I'm not going to get to give you my full lecture on the history of NAGPRA. But I will just say that they are two separate processes in the law itself. And Congress made that choice. Congress made the choice in 1990 to establish a separate process for human remains and associated funerary objects and other cultural items. And that choice actually was made towards the end of some of the last revisions of NAGPRA made that change. In earlier versions of NAGPRA, every Native American cultural item or human remains would have been listed in an inventory, meaning a detailed itemized list. That change was made before NAGPRA was passed, and that's why there are two separate processes. If anyone is interested in the history of NAGPRA, I would highly recommend you start with the congressional reports. You can find those on our website on the law page. We have, you can do what I do, which is make yourself a little book of them if you want. I have all of the congressional reports printed out here. We also have links to the congressional record, which is the summary of the testimony on the floor. And then if you want to be really, really legislatively nerdy, you should go and find the hearings that were held on NAGPRA and read all of the various testimonies. Those are a little harder to get to, and we don't have links to them because in the 1990s, the way that this information is available on the website requires a lot of, it's very big, but we will work towards finding those hearings and putting links to them, so at least you can find a reference to them. So I'm sorry for going a little bit over today. I hope that everyone has enjoyed today's session and that you have a wonderful weekend. Thank you.